Assalamualaikum Doctor. I hope you are doing fine. My name is Nur Hazani binti Anwar. My metric number is 1180195. So today, me and other friends will present for the group presentation that related to the communication law. So I have been given two cases that I will discuss. The first one is from News Straits Time that the title of the man jailed for second time for insulting Agong on social media, and the second is from website Free Malaysia Today that the title of High Court suspends shop assistants sentence for insulting police. So let's start for the first one. Continue to the fate of the cases. The first cases on 6 July 2020, Kuala Lumpur, 2 months behind bars last year, 2019, were not enough for Syaril Muhammad Sarif to repent for insulting the Yang di-Pertuan Agong and Raja Permaisuri Agong. Syaril Muhammad Sarif found himself in the dock again for the second time and pleaded guilty to the 2 counts of the same charge before Session Court Judge M. Edwin Paramjoti. According to the charge sheets, Syaril had via his Instagram account made insulting remarks directed at the Yang di-Pertuan Agong and the Raja Permaisuri Agong with the intent to offend. Syaril's offensive comments were related to a live video on the Istana Negara official Instagram page of the swearing-in ceremony of the 8th Prime Minister on 1st March. Syaril's charges were framed under Section 233, Clause 1A of the Communications and Multimedia Act 1998, which provides a maximum fine up of 50,000 ringgit or up to a year's jail or both if convicted, and a fine of 1,000 ringgit for every day of the offence is repeated after conviction. Next is second case that tell about a woman insulting the police. On 9 April 2020, Alustar, the High Court suspended a 3-month jail term and a 10,000 ringgit fine imposed on a shop assistant, Nur Sahira, 20 years old, who pleaded guilty to insulting the police on social media in relation to the COVID-19 outbreak. Nur Sahira was uploaded the status of to be furious with police directing her to return home when members of the police conducted an inspection of OPS COVID-19 near Jalan Pendang Kobah Road. She was arrested and charged in court after uploading offensive communications and Facebook against police personnel, which had gone viral and garnered public attention. According to the charge sheet, Nur Sahira, through Facebook, intentionally initiated offensive communication with the intention of mistreating others at a house in Persiaran Kiaramas, Pendang at 10:12 p.m. on 27 March. She was charged under the same case before this in Section 233, Clause 1A of the Communication and Multimedia Act 1998 that carries a fine up to 50,000 ringgit or a maximum jail term of 1 year or both upon conviction. Okay, let's continue to the relating case to the communication law. The meaning of freedom of speech is one of the most fundamental rights that individuals enjoy, which give people the opportunity to seek, receive, and impart information, and it is have important conversation of public concerns and hold this in power to account. It is also one of the most dangerous rights because allows freedom of speech means freedom to express one's discontent with the desire to share it. Okay. The internet is powerful and positive forum for free expression, but there must be a limitation provided by the federal constitution. For this case, the published articles are intentionally initiated offensive communication with the intention of mistreating others. Action can be taken against and can be arrested, charged, and it is if it is found guilty can be persecuted under the law. Besides, if that can cause hatred against the government and Yang di-Pertuan Agong, totally it can be arrested.
Warahmatullahi Taala Wabarakatuh. My name is Nur Akilah binti Osman and my matric number 1180197. Today, I would like to present and continue what my friend Hazani Anwar had taught before. She had taught about two news and which is discussed about insulting Yang di-Pertuan Agong and insulting the police. So let's go to the first news. First news is discussed about a factory worker pleads guilty to insulting Agong, Raja Pemaisuri Agong, on Instagram. What he had done, the accused had used offensive remarks which had gone beyond freedom of speech. So the accused was charged under Section 233 bracket 1 bracket A of the Communication and Multimedia Act 1998 and could be sentenced under Section 233 bracket 3 of the same Act, which carries a maximum fine of 50,000 ringgit or jail up to 1 year onwards upon conviction. So, what is Section 233 is talk about? Okay, let's take a look at my slide. Despite the fact that freedom of expression, speech, is guaranteed in Article 10 of the Federal Constitution, Section 233, bracket A, makes it an offence for any person who, by means of any network facilities or network service or application service knowingly, makes, creates or solicits and initiates the transmission of any comment, request, suggestion, or other communication which is obscene, indecent, false, menacing, or offensive in character, with intent to annoy, abuse, threaten, or harass another person. So, Section 233 bracket 3 has talked about the person who commits an offence under this section shown on conviction be liable to fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 1 year or to both. So the last result in these cases is Sharif Muhammad Sharif, who was unrepresented, pleaded for a minimum sentence stating that he had a mental issue. And Deputy Public Prosecutor Muhammad Ashraf Kamal did not propose bail on the ground that the accused had previously been convicted with the same offence last year. The court allowed the accused bail of 16,000 ringgit in one surety for the charge because of the mental issue. So let's go for the second news. Which is talk about the woman insulted the police was arrested. So the name is the accused, Nur Sahira Muhammad Mizwar, 20 years old, was sentenced 10,000 ringgit in jail for 3 months after being found guilty under Section 233 bracket 1 bracket A of the Communication and Multimedia Act 1998. So this law is, the relevant law in these cases is the same like the first news we talked before. The result of these cases is the accused failed to pay the fine, causing the court failed to pay the fine, causing the court to impose an additional 2 months in prison on him. But High Court later allowed the accused application to suspend the fine and 3 month imprisonment. Judge Dr. Licha decided to set bail at 5,000 ringgit, with two sureties besides the accused having to report to the police station every 2 weeks. And also on 15 April 2020, the accused made an apology to all parties, especially the PDRM. She was so sorry for the reckless action that she was willing to issue harsh words against to the police on duty during the implementation of the movement control order MCO. Okay, and Nur Sahira case also received the attention of entrepreneur, which is the name Muhammad Azlan Abdullah Ali from Masjid Terengganu. He is an entrepreneur who is sympathized with Nur Sahira's family and is willing to explain the legal course until the cases is completed. Besides explaining the Nur Sahira bill of 5,000 ringgit, basically his action to help. His action is to help the accused was not because of he supported with this act of insulting the authorities, but rather wanted the incident to be a lesson to all parties, so as not to freely utter the bad communication or words to anyone, especially police and Yang di-Pertuan Agong. So the conclusion is why we cannot insulting the police or Yang di-Pertuan Agong. This is because Malaysia adopts a system of parliamentary democracy and constitutional monarchy, with the Yang di-Pertuan Agong as the head of state. So, through the second pillar of the nation, namely loyalty to the king. Loyalty to the king and the nation. The institution to the king must be respected by the people because it is the symbol and patron of national sovereignty. Okay, so that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Najah Ulfah binti Idris, metric number 1180199. For today, I'll explain an article about Teresa Koch wins defamation suit, awarded 80,000 damages. Firstly, I will explain about the case. The plaintiff, Teresa Koch, is the Seputih Member of Parliament, filed a defamation suit against the defendant, Sharhan Humaizi Abdul Halim, on 4th February 2019. The plaintiff alleged the defendant had published an article entitled Ucapan YB Ustaz Khalil, Benar, DAP Jangan Kurang Ajar, on 9th January 2019 in Selangor PAS Youth Facebook account. She also accused that the defendant produced another article on 12th January 2019 in Malaysia Today news portal entitled Teresa Koch did not agree with Islam as the federal official religion. She claimed the defamatory words in both articles, among others, means that she was racist, anti-Islam, and abusing her power as a minister, and also cannot be trusted and an unethical person. The High Court Judge, Muhammad Firuz Jafrin, allowed the defamation claims by Koch and said that the readers would find the plaintiff as an anti-Islam person, a racist, and give negative implications on her reputation as a politician. He also said that the court considered the freedom of speech is enshrined in the Constitution, but the right is subject to the law, especially the Sedition Act. As the plaintiff Teresa Koch won the defamation suit, the defendant was ordered to pay to plaintiff 10,000 ringgit in costs and 80,000 ringgit for compensation. Next, Relating case to communication law. Firstly, the meaning of defamation. Defamation is the action of damaging the good reputation of someone. In this case, the published articles are intentionally written false information that can harm the plaintiff's reputation and decrease respect for her, especially as a politician. There's two types of defamation. Firstly, slander, and secondly, libel. In this case, libel defamation, because the statement made in a permanent form, which is internet post. This type of defamation is actionable in tort, with no need to prove actual material loss caused by the publication. Next, laws related to the case. Firstly, Defamation Act 1957. The preamble of the Act is an act relating to the law of libel and slander and other malicious falsehood. Next, law related is Article 10 of Federal Constitution. That means freedom of speech, assembly, and associations. That means every citizen has right to speech, to talk, but subject to a few conditions. The next law related to the case is Sedition Act 1948. The preamble of the Act is an act to provide the punishment of sedition. Sedition means the act of criminalizes speech, words, publication, act with seditious tendency.
Okay, Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Mashita binti Muzahar and my metric number is 1180196. Today I would like to talk about the news article that I have chosen. The title is about Jasmine Hamid kemukakan saman fitnah, which is Jasmine Hamid is Malay actress. She filed a lawsuit against 3 individuals on 2 May 2019. This case is about where they have 3 individuals that have gone too far when they ridiculed Jasmine Hamid's daughter about her physics and manually open on social media. Okay, they insulted the face of Jasmine Hamid's daughter, Rohana Abdul Hamid, as a bapo on social media, Instagram. Okay, why Jasmine Hamid filed a lawsuit? Because these bad statement give negative effect for her daughter feelings, give negative effect for emotional feelings. And when this bad statement was published, many people started to give nasty comments. Okay, and the defamatory statement which is sound like this: aku suka mengutuk perempuan maknya yang kerja dekat klinik tu, rupanya anak artis. Okay, and then why it related to law communication? Because the element shows that this is defamation based on these 3. First, defamatory statement. Second, defamatory statement must refer to the plaintiff. And third, defamatory statement must publish to the third person. Okay, based on the defamatory statement that is which I was defamation. Defamation is a word that used to describe both libel, which occurs in writing, and slander, which is spoken. Defamation can harm people's reputations and can lead to injury that can lead to injury lawsuit. Defamation also can harm a person's emotional and financial well-being, also physical. Okay, in this case, it is libel, which is called defamation, which is called written defamations. A person who has been defamed can sue the person who did the defaming for damages. What does the victim need to prove to establish the defamations? If you believe you have been defamed, to prove it, you usually have to show there have been statement that is all of the following: published, false, injuries, and unprivileged. One of the defamation claim element is published, means that a third party heard or saw the statement. It does not necessarily mean that the statement must written what must printed in a book. It just need to have been made public through social media such as television, radio, even gossips and loud conversations. Okay. One of the form of defamatory actions in civil defamation is action under Defamation Act 1957. The plaintiff in this case seek judgment and damages parties involved. Second, in cases that involve IT such as email, messages, and etc. The person that should be responsible is the author, the disseminator, and the supplier of the informations. Okay. And one of the compensation and judgment is in this injunction. In this injunction, aims to prevent the publication or printing to continue in the future. Apolog- uh, Apologizing openly in libel cases. The plaintiff demands that the defendant apologize by means of advertising. Conclusion of these cases, which is this case, the problem was successfully resolved out of the court amicably through some negotiations, terms and condition. The individuals, the Izatul Hara Abdullah, agreed to also agreed to confess her wrongdoings. She also agreed to a public apology orally in press letter, withdrew the accusations and paid damages in joint discussions.
Assalamualaikum warahmatullahi taala wabarakatuh. Good afternoon to Dr. Hazmi, and firstly I would like to introduce myself. My name is Nur Hikmah binti Abdullah. My matric number 1180198. Today I would like to present to you about defamation law on the internet. So the issue I choose for the article, a first for Malaysia, Prime Minister sues website for libel. Okay, we can see for the second slide a card of news article from the Diplomat. So the headline is about the first of Malaysia Prime Minister sues website for libel, and this article and I will explain this article for the next slide. Next, I will explain about the article. First, the article from the Diplomat and written by Mong Palation on 12 June 2014. And it is about country's first prime minister to sue a media organization for libel, which is media organization is Malaysia Kini. They claim that he was defamed by the comments by the readers of Malaysia's Kini's news website. And for Malaysia Kini, for our information, is an independent and award-winning news and award-winning news website, and they applied a license to publish a newspaper but was denied by the government in 2012. Referred to what I had stated in when Najib was defamed. In other words, Datuk Sri Najib also suing Malaysia Kini, not publishing a libelous news story, which is allowing libelous comments to be posted on their website. So, the libel was filed in regard of refuse for Malaysia Kini for apologizations, and they also made and alter in particular section in article. So we can see below from my points, that I put below of the slide. One of the comment written by anonymous hashtag 019884881 criticized the moral competency of Najib, suggesting Prime Minister has many skeletons in his closet. And also, there are two defamatory was published on 14 May 2014. New article, Malaysia Kini news website entitled a case of the PM raping what he saws, and entitled also how much will Najib spend to keep Terengganu. So this statement were defamatory to him, and Datuk Seri Najib has filed as libel to him.